In a stunning turnaround, Allahabad High Court sets aside guilty verdict against parents Nupur and Rajesh Talwar, convicted by a trial court for murdering their daughter Aarushi. We are the real victims. Why punish us? Said Nupur Talwar in a most recent interview taken by a social worker in jail last year. It seems the judge heard her call. Parents get justice after 4 years, shed tears of relief, but Aarushi is yet to get justice after 9 years, and neither has Hemraj, the domestic who was murdered. Following 3 investigations and 2 verdicts, there is still no clarity on who murdered the teenager. Will the investigation agency accept responsibility for the injustice they've done? Testimonies of Talwar's domestics recorded under truth serum absolved Aarushi's parents, but the investigators, for some reason, inexplicable reason, never investigated the leads. Were narco tapes buried? Nine years after a 14-year-old and a domestic employed with her parents were found murdered, we were told today, in effect, no one killed them. For the last 4 years, the CBI had convinced us that the trial court was right to have jailed Aarushi's parents, Nupur and Rajesh, for her murder and for their domestic, Hemraj, on the back of their meticulous investigation. They said that our investigation was so foolproof that no court in the land would be able to overturn the guilty verdict and the life sentence that was handed out to Aarushi's parents, Nupur and Rajesh Talwar. Well, today, the High Court has ripped through this claim and absolved the Talwars of the gruesome, brutal murder. The court has proffered some hard facts, which I'm going to refer to up front. That's right, up front on your screens are the hard facts. Talwars can't be convicted. First of all, can't be convicted based on suspicion. There you can see these hard facts, ladies and gentlemen. They're on your screens. Coming up second, benefit of doubt must be given to Talwars. If there was foolproof evidence, ladies and gentlemen, there would be no question of benefit of doubt. CBI couldn't substantiate the evidence. This is perhaps the harshest observation that has been made against the investigative agency. The court didn't stop there. It went on. Prosecution failed to prove Talwar's guilt beyond reasonable doubt. Now remember, all courts need evidence to suggest that beyond reasonable doubt, guilt has been established. The chain of events were not conclusive for the 2-judge bench of the Allahabad High Court. Fundamentally, ladies and gentlemen, fundamentally, you have a situation where the court came away completely underwhelmed by the thrust of the CBI's case. If the Talwars are innocent, is it safe to assume that the domestics then are guilty? Are they back to being suspects? Who are we talking about? Rajkumar, a domestic help at Talwar's friend's house, who is supposed to have been infatuated by Aarushi. There's another suspect, suspect 2, Krishna Thadarai, assistant at Talwar's clinic. There's another one, Vijay Mondol, domestic help of Talwar's neighbor. And then, of course, you have Hemraj himself, who unfortunately is dead. So we will never know if he was part of a conspiracy that went horribly wrong. Well, Rajkumar, domestic help of Talwar's friends, Vijay Mondol, domestic help of Talwar's neighbors, Krishna, assistant at Rajesh Talwar's clinics, are now perhaps active suspects. It may not be an unreasonable proposition. Times now has accessed narco tapes. that seemed to suggest that Talwars were innocent. Listen to this admission from Rajkumar, who was Dr. Rajesh Talwar's friend's domestic help. Suspect number one now, given that the Talwars have been let off. Listen to this. It's very interesting, this narco tape, for what it really implies. It throws up a major contradiction, because in this particular narco tape, this individual can be heard admitting that he raped Aarushi Talwar, a 14-year-old girl. Listen to this, and then wonder why the CBI didn't think that this was evidence that provided a lead that should have been actually pursued.
वो कुकरी ना,
हाँ जी,
तुम अपने साथ कैसे लेके गए उस दिन?
मैं लेके नहीं गया।
नहीं, तुम थैले पे लेके गए या पन्नी में बांध के लेके गए उसको?
नहीं, मैं नहीं किया।
कैसे, कपड़े में बांधा था क्या उसको?
नहीं।
फिर कैसे लेके गए तुम?
मैं सर लेके नहीं गया।
फिर कहाँ गया वो कुकरी, कहाँ गया?
पता नहीं सर।
किसने लेके गया?
पता नहीं सर।
किसने लेके गए तेरे?
सर
कुकरी किसने लेके गया?
पता नहीं सर।
तुम कैसे लेके गए कुकरी, बोल।
हाँ जी,
तुम कैसे लेके गए कुकरी?
मैं लेके नहीं गया सर।
नहीं, उस खुली जगह में फेंकने के लिए तुम कैसे लेके गए?
मुझे नहीं पता।
कैसे लेके गए तेरे? तुमने, कृष्णा ने तुमको दिया था ना कुकरी लेने के लिए, जबरदस्ती करके तुमको कुकरी दिया था ना?
नहीं।
ये मारने के बाद कृष्णा ने तुमको जबरदस्ती में दिए थे ना?
नहीं।
तुम कैसे लेके गए थे, बोल?
नहीं।
कैसे लेके गए थे, बोल, अंदाज में बोल।
नहीं।
थैली पे डाल के गए थे?
नहीं।
न्यूज़पेपर में रैप करके लेके गए क्या?
नहीं।
फिर कैसे लेके गए?
नहीं, आरुषि मेरी की बहन जैसी लगती है,
इसलिए तुमने रेप किया?
इसलिए मैंने कभी गलत काम नहीं कर सकता।
फिर क्यों तुमने उस दिन रेप किए? रेप तुमने क्यों किया उस दिन? मारने के पहले तुमने रेप किया ना? मारने के पहले तुमने रेप किया था ना आरुषि को?
वो तो कृष्ण के पता नहीं क्यों बात है।
कृष्णा ने तुमको रेप करने के लिए जबरदस्ती किया क्या?
हाँ जी।
कृष्णा ने तुमको जबरदस्ती किया रेप करने के लिए?
हाँ जी।
हाँ बोल, वो खुलकर बोल। कृष्णा ने क्या किया रेप करने के लिए?
उसने बोला कि आज तक तुमने कुछ नहीं किया, कुछ नहीं किया।
नहीं रे, वो जबरदस्ती किया क्या तुमको रेप करने के लिए?
हाँ जी।
हाँ बोल, मुंह खोलकर बोल। कृष्णा ने, बोल, कृष्णा ने
मुझे बोला कि आज तक तुमने कोई गर्लफ्रेंड नहीं है, तब तू क्या करेगा? ऐसे बुढ़ापा हो गया तो शादी भी नहीं होगी, ऐसा बोला था।
और रेप करने के लिए कहा ना? हाँ?
नहीं।
बलात्कार करने के पहले रेप करने के लिए कहा ना?
नहीं।
क्या कहा फिर? कैसे रेप करने के लिए बोला? तुमने खुद गया क्या रेप करने के लिए?
Well, that was a narco analysis that was conducted on this particular domestic. It moves from absolute denial to an acceptance of loneliness and of one other individual, Krishna, trying to instigate a situation. Though in this particular narco tape, you had a situation where this particular domestic did not admit at any length to having murdered Aarushi. There seems to be some indication that he might have been spurred on, perhaps, to do something else. We can't, at face value, hold anyone guilty. We're not investigators. We're only putting out what we have accessed. And I want to go across to Bhavtosh. Bhavtosh, Rajkumar, one of those who claims that he was being sort of instigated to have some sort of an equation with Aarushi. These were leads. There have been other narco tapes which have been accessed in which Rajesh Talwar's assistant said saw Rajkumar, another domestic, help kill Aarushi. Hemraj witnessed Aarushi's murder, so was killed. Aarushi was killed from behind with a kukri knife. Hemraj was killed with a blow to the head. All of this was there. Some of these narco tapes were there. Why did the CBI not consider them reliable enough?
Well, Anand, Rahul, in fact, the investigators, the first investigators of CBI took on to record these narco tapes and in fact arrested Rajkumar, also Vijay Mandal and Krishna. They claimed that it was there was a party at Talwar's residence. Talwar couple were sleeping. They had whiskey. In fact, they had Valentine whiskey. After which they tried entering inside the room of Aarushi. Hemraj objected to this, and then they first dragged Hemraj to the terrace where they killed him, and then also covered his body with a blanket and then went downstairs because Aarushi was awake, and then slit her throat with a kukri. This was mentioned by Arun Kumar, the then joint director, in a press conference that was held on 13th of July 2008, after which Dr. Talwar managed to get bail. Now, why it was not taken on record by the second team? According to CBI, many of the questions that were being asked by the forensic experts were leading questions that were leading to an answer, and that is the reason why they say they never took it on record. Interestingly, Sunil Dhore, the one who conducted the post-mortem on Aarushi, also admit that he received a call from someone claiming to be T.D. Dogra, the then forensic head of AIIMS, and he in fact said that do not mention the word sexual assault or rape in the post-mortem. So both the CBI team were aware that there was a sexual assault on Aarushi, but both the teams refused to add section 376 of IPC and only made it a case of murder and destruction of evidence.
Would this be also true of Krishna and Vijay Mandal, whose narcos were also conducted, and we can see on those graphics that they also suggested that one among them actually committed the murder? Well,
Rahul, if we go by what the CBI first team had said, the sequence of event of the night of 15th May goes something like this. That around 10:30, Krishna made a call to Rajkumar telling him to come to the residence of Dr. Talwar. Hemraj was inside the house. He opened the door, and then Krishna, Rajkumar, Krishna and Vijay Mandal. Vijay Mandal was a domestic help of the neighbor Tandons who live a floor below Talwar's. They came to the room. They all had a whiskey. And then they decided to sexually assault Aarushi. At that point of time, Hemraj resisted. Krishna was in fact the first one to be detained even by the UP police. One must remember that on 19th of May 2008, the first to be detained by the UP police was also Krishna. It was only on 22nd May that the entire police's focus changed and Dr. Talwar was arrested on 23rd. So there was some initial suspicion that Krishna could have committed this crime. The CBI second team believes that narco test was not leading to any concrete answer and it's not admissible in the court. That's the reason why they never pursued them. But interestingly, the second team in the closure report did not even mention the statement of Krishna, Rajkumar and Vijay Mandal. Their statement were not even put on record by the CBI. So it's now up to the CBI to decide how they will challenge this order, because earlier in the day, a former director of CBI, AP Singh, spoke to us and said that he also wanted a closure report to be filed because he knew the evidence that they had on their hand was not enough to even pursue this case in the lower court.
Okay, stay on with me. Athar Khan is also there. Athar, we have heard that in court, and you were there, of course, witness to some of the proceedings, we are being told that the CBI was given a dressing down and their case was full of loopholes. Could you just go over some of the points?
Today, Rahul, of course, I wasn't inside the court. I was just outside of it. But yes, in Ghaziabad, I did attend some of the hearings of this particular case. But clearly, the CBI's position, not just in the trial court in Ghaziabad, of course, today was sort of ripped to shreds because they based their entire conviction on one particular point, which was that Aarushi and Hemraj were intimate. It turns out that wasn't the case. And the higher court saw that today, the division bench coming calling out in pre-written judgment and clearly suggesting that there was an erroneous judgment and large portions, alternative theories, as well as some of the evidence wasn't even looked at by the CBI, essentially initially by the Noida police as well. But during the course of the investigation, the CBI didn't either want to look at it or perhaps missed it. In fact, Bhavtosh pointed out just now, Mr. AP Singh spoke to us earlier today, and he came out clear. He came out very, very clear today that the CBI wasn't in a position to file a charge sheet. And the closure report also was something he didn't really have any faith in, given the fact they had used elimination instead of concrete evidence gathering against the Talwars to convict them. The court ultimately, as we all know, essentially did convict them on the basis of circumstantial evidence. And today it was proved in court today that that circumstantial evidence wasn't enough to convict the Talwars because there was a shadow of a doubt, in fact a large shadow, and they couldn't convince the court, and the court did give an erroneous decision.
Well, let me throw this open. Thanks indeed for joining us. Bhavtosh will be there with us because I'll come back to him in just a few moments. We are joined by Manish Gupta, director of Rahasya, a film that was made in which the conclusion was unambiguous that the Talwars were not guilty. Maxwell Pereira, former IPS officer, is with us. Swapnil Kothari, a lawyer. Arima Sundaram, a senior lawyer. Mrilanani Deshmukh, another lawyer. Also with us is Tanveer Ahmed Mir, who is the defense counsel for Nupur and Rajesh Talwar. Thank you for joining us live from Allahabad. Also with us, Rohit Koshar, senior lawyer. I'm going to go straight across to you, Tanveer Ahmed Mir. Obviously, you feel very vindicated and triumphant today. But how is it that the trial court could differ so greatly from the High Court?
Can you repeat that question? I have a bad connection, Rahul. Can you? I'm so sorry, I couldn't get your question.
How is it that the trial court differed so much from the High Court?
Well, I would, if you recollect, Rahul, that I joined the Talwar trial in summer of 2012. Major part of the trial, running into about 28 witnesses, were cross-examined by me, and then about the statement of accused, about 8 counts of defense testimonies.
Yes.
We had a very strong argument before the learned trial court as well. But unfortunately, if you look into the trial court judgment with all the respect to the learned trial judge, you will see that in that judgment, the court has almost gone on an expedition to replace normal English with middle-aged French, middle-aged Latin. And when it came to appreciation of evidence, I think common sense took an adjournment. That judgment suffered from colossal blunders and infirmities. I would certainly believe, in terms of the appeal that I drafted for more than 20 days and lodged it before the division bench of Allahabad High Court, that the trial court virtually convicted my clients only on consideration of examination in chief of witnesses. The trial court did not go into the cross-examinations at all. In the appeal, we argued the matter for a period of around 4 months. We argued on 16 sets of different circumstances, including all the circumstances that were delineated in the trial, entire evidence, 39 counts of prosecution testimonies, 8 counts of defense testimonies, about 5,000 exhibited documents, and not even one circumstance provided any kind of inculpatory evidence against my clients. The fundamental edifice of the prosecution case was that whether Hemraj and Aarushi were together in that room and whether they were assaulted and murdered there. Now, the Honorable Division Bench clearly returned a finding, which was our argument, which was my argument in the trial court as well, that this was a case where evidence suggested that Hemraj was assaulted and murdered on the roof alone, and Aarushi was assaulted and murdered in the room alone. Secondly, the prosecution case rested on the edifice that in the night intervening between 15 and 16 May, the outermost door leading to the apartment was bolted from inside. The Honorable Division Bench completely debunked this theory and agreed with the defense counsels. On each and every circumstance, we were able to convince the Honorable Division Bench. That is why today, when the verdict was pronounced, both honorable judges have written separate judgments and they came to a categorical conclusion that my clients were innocent right from the word go. And today, the fact that they were innocent, they are innocent, and they will remain innocent has been endorsed.
Okay. Arima Sundaram, is this a failing of the CBI, or is this really a failing? Is this the failing, Arima Sundaram, of the CBI, or is it a failing, sir, of the trial court?
Look, Rahul, I hope I'm clear because you're not very clear to me. I hope I'm clear in what I'm saying. The point of the matter is, let's understand one very simple issue.
Yes.
The judgment of the trial court has been reversed, holding that there was reasonable doubt, that the case was not proved beyond reasonable doubt, in that the evidence as adduced could not clearly, unequivocally establish the guilt, which is the right test to use in the case of any murder or criminal case. Now, the point of the matter is that before the CBI even got into it, the initial stage, the investigation had been so completely botched, the entire murder scene had been messed up, that evidence could not be gathered. This is the reason why the CBI itself filed a closure report. The CBI's closure report was very clear. According to the CBI, the suspects were the Talwars. However, the evidence that they were able to adduce because of the nature of the murder scene soon after it had been so totally messed up, and otherwise the evidence they had been able to adduce would not be able to sustain a finding, an unequivocal finding beyond reasonable doubt of guilt. So the CBI said, look here, our suspects are the Talwars. However, we do not believe that we have the evidence by which we can convict them, and therefore filed a closure report. It was not their case that it is our case that the suspects are somebody else. They had gone on the basis that according to the CBI it was the Talwars, but the evidence was insufficient, and therefore they didn't want to file the charges. However, the trial court didn't accept the closure report, went ahead, and what the High Court has found is exactly what the CBI said in its first report, that the evidence was not sufficient to convict. Now, insofar as the others were concerned, two things I think you should point out is that although the narco test itself was very, very faulty, whatever came from the narco test they did seek to follow up on. But from my understanding, and you can check this, I'm not sure, you can check this with the CBI themselves. My understanding is there were iron cast alibis for people on that night who were not present, and with those alibis it would be seen that they were not even present in the flat when the occasion took place. They had iron cast alibis. If they had iron cast alibis, even one or two of them, that means a statement that the three of them were there was not correct. The CBI, considering everything, honed in their suspicion clearly on the Talwars, but also said we don't have the evidence to prove it. Now, that has now been proved, that they really didn't have the evidence to prove it. That's what the High Court says. And the High Court has not said somebody else committed it, nor has the High Court said that...
So you're saying this is not an absolute clean
chit? This is a case of a botched up
it's not a
investigation on day one.
Okay, it's not a certification of innocence necessarily.
It's not a certificate.
It is the inadequacy of the CBI to prove its theory that is today being basically exposed. Okay, 1 second. Before I open this out.
Absolutely correct.
Okay, I'm going to take a very short break. Mr. Mir,
correct.
I will come straight out to you to rebut that point. I will come straight back to you to rebut that point, Mr. Mir, in just about 3 minutes. Stay with us. Don't go away.
Give me a chance to rebut that point, Rahul.
I will for sure. I will for sure. Just give me 3 minutes. We come back to the rest of the panel.
I will.
This is going to get interesting. Don't go away.
Thank you.
An astounding twist in the Aarushi murder case. 9 years after she was murdered, the High Court today has let her parents off, absolved them, so to speak, of any role in her murder. The High Court has in fact come out and said that the Talwars can't be convicted based on mere suspicion, that the benefit of doubt must be in fact given to the Talwars. This is a massive setback for the CBI that had claimed that the Talwars, the parents, had actually murdered Aarushi because they found her in a compromising position with their domestic help Hemraj, who was also, of course, brutally murdered in the course of the events that unfolded on that fateful night back in 2008 May. On our show, Arima Sundaram, senior advocate, has come out and said that this is not a certificate of innocence by any standards for Aarushi's parents. Tanveer Ahmed Mir, who is the counsel for
Can I rebut that,
Nupur
Rahul?
and Rajesh Talwar, wants to rebut.
Yes.
He has a different take. Let's go over to him. Go ahead, sir.
Yes, Rahul, thank you. Actually, Rahul, when the verdict was today pronounced, the Honorable Division Bench, normally in a murder case, when an appeal is heard, it is one of the judges who writes the judgment and the other honorable judge concurs. This is a case where both the honorable judges have written separate judgments. Therefore, operative portion was written there and then in the court, and it was pronounced. Now, in the operative portion, the honorable judges categorically stated and returned a finding in an open court that this was a case where in the night intervening between 15 and 16 May 2008, outsider ingress could not be ruled out. Secondly, what was categorically stated in the open court was that the prosecution case covenanted alternative theory killers in its own self.
Okay.
Thirdly, it was said that the CBI case that the outermost door was closed is disbelieved. Then the honorable judges categorically said that on the evaluation and analysis of the entire evidence led before the learned trial court, we come to the conclusion that the appellants are innocent. It's not a case of benefit of doubt. My clients have been held to be innocent.
Okay.
They have been honorably exonerated.
Honorably exonerated. This is
And
not.
that is the judgment as
This
on
is not
date.
to be read down.
Honorably exonerated
says
is
Tanveer
the
Ahmed
word
Mir.
that is to be
They've
used.
been honorably exonerated. Rohit Kochar, do you agree with this point of view? Or do you believe that this is a botch-up investigation by the CBI? There could only have been actually 4 people in that house, as the CBI has contended. And therefore, because the others have had watertight alibis, there could only have been 2 murderers, and they were the Talwar couple. Now, where do you stand, Rohit Kochar? And I'm going to go across to the others on this panel.
Rahul, my opinion is that in today's debate, it's unfair to start raising questions about the innocence or the guilt of the Talwars, and I agree with the counsel for the Talwar husband and wife team that we should accept with grace and with fairness the judgment of the High Court. And what I also find rather shocking, in fact, if I can go back to the judgment of the CBI court of 26th of November 2013, what I find shocking is for a CBI court to convict Nupur and her husband and award them life imprisonment in a case where the evidence is circumstantial and not conclusive. Is human liberty really so cheap? Can you take away the entire life of 2 accused persons based on evidence which admittedly is not direct but circumstantial in nature? As a father of two young daughters, I have not, of course, I have not been involved in this case as a counsel, but as a parent of two young daughters, I've been emotionally engaged with this matter.
I understand that.
I felt
but
very
there is
sorry
no room for emotion, sir,
for
in a court of
the
law.
Talwar family when
You have to go by the facts at hand. You can't sort of go by the weight of emotion, because if that were the case, then judges would be
so I've spoken so Rahul,
easily swayed.
Rahul, I spoke about, once again, I spoke about, I'm tying in emotions with a legal point. I said that a CBI court cannot convict an accused based on circumstantial evidence.
Okay.
The second point I want to make is...
Especially parents. Okay, fair enough. No, let's go point by point. I don't want this to become too complicated. Let's go point by point.
No, let me...
Swapnil Kothari...
I want to make a second point.
No, 1 second. I'll come back to you, Rohit Kochar. You'll have enough time. Don't worry. We've got 30 minutes on this show. Swapnil Kothari, on that opening comment, do you agree this is a clean chit? Or do you believe that this is not a certificate of innocence? Where do you stand, sir?
Well, I endorse the viewpoint of Mr. Aryasundaram, who so very lucidly pointed out the factual history of the case and as to how it reached the trial court and how the trial court came to convict the Talwars. What the High Court of Allahabad has said today is that we do not find enough evidence, or we are not convinced enough to uphold the conviction. They have not said that we find evidence enough to uphold or to acquit them. So it is definitely not a clean chit. This opens up an alley where the CBI can still pursue this in the apex court and try to ensure that what it said before the trial court and try to convince the Supreme Court about the same. My point is very simple on this issue, is that if the CBI came to the conclusion, what Rahul has gone against the CBI in this particular case is that there were two conflicting theories by the same investigating agency, that is the CBI. First it did not point fingers at the Talwars, and then in the second one it pointed fingers at the Talwars. Yes. So that is what has probably cast a little bit of a shroud of secrecy or suspicion over the fact that there is not a preponderance of evidence enough to establish the conviction of the Talwars, so we will not uphold that conviction. So what is imperative here is that there has to be a preponderance of evidence. Now, if that is lacking, then the High Court of Allahabad will definitely not uphold that conviction. Now, usually what happens is that the first responders were the UP police. Yeah. Now, as Mr. Sundaram pointed out, is that there was not much of the evidence was washed away.
I understand that. We'll come to that. What happens next, we'll come to. Should there be a reinvestigation? Is there even a capacity for a reinvestigation? But Ms. Deshmukh, let me come straight out to you. Now, when the court says benefit of doubt must be given to Talwars, that isn't exactly a wholehearted endorsement of their innocence, is it?
No. We will have to appreciate that the criminal judgments are given on beyond reasonable doubt. Civil thing, there is preponderance of probability. So if the courts have to use those yardsticks to decide a particular case, and they have said that there's not enough evidence which is there. So whether it amounts to completely exonerating them, declaring them to be innocent, as the counsel for the Talwars has said, or not, is something I think we'll have to read into the entire order to come before it and not really go by the operative part of it. I completely endorse the views of the senior counsel, Mr. Sundaram, when he says that it was negatively put, if I may put it in that manner, that okay, since we cannot find something on it, doesn't mean that they have been completely given a clean chit, is what I believe is the essence of the judgment that has been given in this particular case. So I think it's a little long way to go. I would not say that it is completely a triumphant note as far as the Talwars are concerned. Yes, but the Allahabad High Court judgment has really given them a little bit of strength, if at all the matter, then I'm sure it will go to the Supreme Court to deal with it. But I don't think that it is
The tragedy is we won't be having this conversation, because while someone could say, and Mr. Mir will say emphatically, that the Talwars have got justice, their daughter hasn't got justice, and someone must take responsibility after 9 years.
So who has killed Aarushi?
And that's
Rahul,
it. That's
who
the
has
point.
killed Aarushi?
So we'll come to that point. But right. Mr. Maxwell Pereira, the police force. I'll come to you.
Can I, Rahul, give you a 1 point on that?
1 second. Let me come out to Mr. Maxwell Pereira. 1 second. Give me 30 seconds. Former police commissioner. I just want to ask him. Mr. Pereira, should the police today and the CBI be investigated for doing a shoddy job and denying a 14-year-old justice and the family of Hemraj justice?
It will all come out in the appeal that is going to the Supreme Court if they want to make an appeal. That having
Connection
said,
is gone.
I would like to point out that before the judgment came out or the verdict, the appeal verdict came out, I had tweeted on Twitter about the possibility of what the result would be, and I had predicted acquittal. And on the very same grounds on which the justices have given the acquittal. The benefit of doubt, insufficient evidence, and all these things which I had very clearly indicated. But throughout the trial, throughout the debates that were going on at the trial stage, I was one of those who had convinced myself that the parents had no answer.
No, but one second. Mr. Pereira, I asked you a very direct question. If the
killers.
parents are so guilty,
Or who
and
else
if the
could have-
CBI built a case around their guilt, why is it that their case has today fallen flat, and should they be answerable to somebody, to some authority? Should they not be probed? Should not the police, the first responders, not be probed? Simple question, sir.
I think you didn't hear what I said.
I
very
didn't.
clearly said that I had predicted this acquittal.
You might have predicted it, but I'm asking you, what now? Should these
I had
investigators not be
predicted this in
probed?
my tweets.
No, so I don't think you're understanding my question at all, or you're deliberately evading
well.
an answer. I'm asking you, this is a sterling indictment
Rahul,
of the
let me answer your question. I think you should leave
investigators.
the,
Should
leave
they
the
not be
investigating
made
agencies
accountable?
alone.
How long are people in the criminal judicial system going
No,
to
because
suffer?
I think
because
Mr.
of
Sundaram has very
bumbling
clearly
police?
shown the whole
That in every
process.
case,
First of all,
there must
the
be a
first
conclusion.
report was a closure. The final
No.
report
I think,
on
Mr.
which
Pereira, you've
the
kind of
case
not
carried
understood the
on was
question.
also
I'm
a
not
closure
going
report.
over the facts of this case. I'm asking you, as a former police officer, either you're so wedded to your uniform and so loyal to the force that you can't bring yourself to say that the police must be prosecuted for this botch-up.
Yes.
Should they not? I'm asking you a simple question.
Oh, the botch-up, definitely, I'm sure the department would go ahead with whatever action that has to be taken.
I don't think any action
By
is
the
ever
way,
taken in
I'm
these
of the
matters unless
impression that,
it's brought up
the
here.
acquittal reports are
It's
just,
brought up here in the
buried
media,
under the
and
carpet.
pressure begins to build. Whether it was the
in
case
my
of the stampede in
experience, every
Mumbai
single
or any other
acquittal
incident,
report
the
is-
authorities never want to
Please
take
give
it
us a
upon
chance.
themselves.
Listen, don't go on, it is not a one-sided debate. No, you don't
I
give
agree,
a chance to
I
anyone
agree
to
with
speak
the
their,
retired police commissioner.
whatever
Rahul, I would like
the
to come in
contention
here
is. And
and make a point
the basic thing is
about
that
the
no
question you
acquittal
raised.
goes without being gone into.
Okay.
And every single acquittal, the investigators concerned are answerable.
Well-
and these things carry on. People lose their seniority, people lose their
Manish Gupta, what do you
increments.
believe?
So many punishments are there.
Well, sir,
this is
let's
I mean,
see
I'm
some
making it
evidence
very
of that.
clear If the public
I'll
doesn't
take it
know
at
about
face
this.
value. I'll
And-
take what
and
you're saying at face value, but I'm not
acquittal
believing
is
you.
left
1 minute.
aside.
Mr. Manish Gupta, what do you think is the next course?
See, there's no conclusion as such, according to me, because the matter now will be taken up in the Supreme Court, because the CBI will be filing an appeal. So this goes on. There's a lot of ambiguity surrounding this case, because first of all, there were two murders, not one murder, two murders. And there are so many characters involved. There are so many people involved. Secondly, well, they have been acquitted. But who has killed her? Do they have conclusive proof that the servants have done it?
Yeah.
So that's still not been proven. So there is still ambiguity around this case.
So
which will continue, I guess, which will continue.
If the
until
Talwars haven't done it, then who's done it? That becomes the million-dollar question, doesn't it, Mr. Mir? You must have some idea, some
Rahul,
inkling.
who did it? I will tell you. You come to me. I'll tell you who did it.
Tell me. Tell me, sir.
So can I answer that? Or
One
should
second. The man who's
Yes.
conversant with the
If I
facts.
got required on the panel, I can leave.
Can I now?
Yeah, go ahead, Mr. Mir. Go ahead. Go ahead, sir. Tell us.
Rahul, what should not be forgotten in this case is that in June 2008, when the CBI took over investigation from the shoddy investigation which was done by Noida police, they conducted certain scientific tests on the Nepali domestic helps as well, this Krishna, Rajkumar and Vijay Mandal. Pursuant to that, a raid was conducted on the room of Krishna where a pillow cover was seized. That pillow cover was sent to a dedicated DNA forensic laboratory called CDFD Hyderabad. On 6th of November 2008, there was a report according to which DNA and blood of Hemraj was found on Krishna's pillow cover. Therefore, this Krishna had to be around Hemraj when Hemraj was assaulted. That is why blood of Hemraj, when it spilled from the blow on his head, got embossed on his hair follicles. Now, most unfortunately, when Talwars got summoned 3 years down the line, this CDFD Hyderabad suddenly comes with a clarificatory letter where it says that we have committed a typographical error in one of the most crucial pieces of evidence. And they wanted the court to believe that you treat the typographical error as what? You read the result of item number 14 as that of 24.
So, but why would anyone want to go out of their way to incriminate the Talwars, the parents?
This was completely demolished by the
But why
High
would
Court.
they want to go out of their way? What special love or
Sir,
brief
you have to
did the police
understand.
have
I'll tell
for the
you why.
Talwars?
I'll tell you why.
Or for the domestics that wanted them, sort of push them into framing the Talwars. I mean, that sounds a bit strange, but okay, we have accessed Krishna's narco analysis. Listen to this. It's quite interesting because the question is asked, which weapon did you use, which one was it, and from there it unfolds. It's about 1.5 minutes long, and I'll come straight out to Rohit Kochar as well as Mr. Aarushi. Let's play out that.
कौन सा हथियार इस्तेमाल किए थे? कौन सा हथियार? कौन सा हथियार? कौन सा हथियार इस्तेमाल किए तेरे? क्या? एक कुकरी में खून का डब्बे थे ना? हाँ? कुकरी में खून का डब्बे थे क्या? हो सकता है ना? खून का डब्बे ना वॉश किए थे क्या पानी से? कहाँ पे वॉश किया होगा? खून का डब्बे? क्या?
फ्लश में डाल दिया होगा।
कौन सा जगह पे क्लीन किए थे? कहाँ पे फ्लश किए थे? हाँ? कहाँ पे फ्लश किए थे?
वहाँ पे नीचे टिश्यू पेपर करा था ना।
कहाँ मिला टिश्यू पेपर? टिश्यू पेपर कहाँ मिला था? हाँ? टिश्यू पेपर कहाँ पे था? हाँ?
Well, Krishna then nodded off to sleep. So we don't quite know how that concluded. We only have that part. And I must say that since it's an extract, it might be only a selective representation of what really transpired. Arima Sundaram, Rohit Kochar first, because you were raising your hand. Go ahead, Mr. Kochar.
I have a question.
Yeah. So, Rahul, I have two fundamental problems with the way this debate is being raged.
Okay.
One is, we must remember, acquittal is acquittal. The law does not distinguish between an acquittal where there's a clean chit and an acquittal because of lack of conclusive evidence. So let's not be unfair to the accused who've suffered an ordeal of 9 years. That's the first point. The second point is very important, and I would ask you not to interrupt me and allow me to complete it.
Sure.
You emphatically asked the retired police commissioner and also the counsel for the Talwars that should the CBI not be probed, should action not be taken against them, because we don't have a conclusion on who killed Aarushi Talwar. That is dangerous journalism, because it applies pressure on investigation agencies to nail somebody down even in cases when they do not have conclusive evidence. And Rahul, it is all right. It is all right for some cases to remain inconclusive.
I think you misunderstood me, Mr. Kochar. I need to correct you.
Cannot pinpoint.
I was only seeking a probe. No, one second. Since you misquoted me, I need to quickly come in and correct the picture.
Rather than
no, excuse me, Mr. Kochar, listen to me. I think you might have got the wrong end of the stick to beat me with. Just a minute. I said for the botch up in this probe.
Arnab Goswami.
Oh gosh, are we going to listen to now some tirade? Excuse me, Mr. Kochar. Can you please listen to me?
Necessary.
Okay, can you please listen to me, sir? You might have your various peeves with various different anchors. I only said that if there has been a botch up in this particular case, there quite clearly has been, should the botch up not be probed? I did not say that they did not read to a conclusion. I'm not dumb, sir,
no.
And neither am I ill-informed. And neither do I jump to any sort of conclusions, and neither am I appropriating or in any way appointing guilt in this particular debate. I'm only asking questions which would legitimately occur to anyone. And therefore, let me bring in Arya Sundaram. No, excuse me. 1 second, sir. You've said your point. We shouldn't be jumping to a guilt. No, we shouldn't be jumping to appropriating any sort of blame or imputing any. So I'm going to go back to Mr. Arya Sundaram. Mr. Arya Sundaram, the point is, an acquittal is an acquittal, says Rohit Kochar. Is he right? Is he wrong? Can there be shades? Can there not be shades?
I think it's self-expressive, Rahul. An acquittal is an acquittal. There's no doubt about that. The point I was making was something completely different. Of course, an acquittal is an acquittal. But the point I was making was, does this mean that there should be an investigation now to find out who actually killed Aarushi, that it was not the Talwars who did it, ergo there must be somebody else, ergo there's a murderer on the loose, ergo find him, he's the person to go against? I was saying that is not the necessary conclusion. There are a number of cases where the accused who have been charged, who are maybe even the only suspect in a case, maybe a person whom the complainant himself or herself says is the person who's committed the act, is thereafter acquitted because of paucity of evidence. Now the point here was that the CBI came to a conclusion after examining everything that the suspects were the Talwars. The CBI also said very clearly, although that is the case, we find we don't have enough evidence to convict. The effect of not convicting is acquittal. Now that does not mean, it therefore means that there is someone else who has committed the murder, who is out in the loose and who has to be found.
Yes.
That is not the necessary conclusion, that is not the sequitur, and that's what I was pointing out.
I think that's a very, very important point. The first CBI investigator in this case has tweeted, and I'm being told...
Can I rebut that, Rahul?
Yeah, okay, quickly come in. Mr. Mir, while we put out the tweet on air. Yes, go ahead.
I'll tell you, Mr. Sundaram, because he may not have looked into the evidence of the case, and since I did the trial and I led the appeal, I know the case inside out. Let me tell you that the conclusion of the CBI that there was some suspicion against the Talwars was based on manipulated witness statements. Not even a single witness who testified for prosecution in this case can be termed as a witness of sterling quality, giving an unimpeachable evidence
character. But that still leaves us, Mr. Mir, with the big
when the second
question.
team of CBI
then who
started
did it?
The investigation.
Then who did it? Certainly there were other people who must have done it then. If it's
you
not
see, that is not
your
that
clients.
Rahul is not an answer which I should be giving, because
not. And
that is for the investigators.
And therefore, what
that
Mr.
question
Arya
has
Sundaram
to be
said,
answered by Noida Police.
I understand, and
CBI.
that's why, sir, what Mr. Arya Sundaram said stands.
I'll tell you that my clients were framed in this case.
I can completely empathize with you, sir, but that doesn't quite mean that there were other individuals. And it also doesn't mean that there were not other individuals. And that's
Well,
precisely what Aryama Sundaram is saying.
There
Now, one
were,
second.
Rahul.
Exactly.
No,
I
one
just
second. We
told
don't know,
you
sir.
that
I
there
don't
was
want you to
clinching
sit here.
DNA evidence
I don't have the other side.
against the set of accused
But the
persons.
Aarushi verdict,
What do
Arun
you-
Kumar,
what
the
more
first
did you
CBI
need?
officer says, and this is the big breaking news, my only concern is how do we ensure that this is not repeated with any other case? It was worth pursuing the truth. God, this is what he has said. And if there has to be no repeat, then these individuals who messed up need to be brought to account so that they are made an example of. We leave it at that. Navika Kumar takes this forward on the News Hour.